Senator Menendez, you recognize, sir.
Thank you, Mr. President. Sir Creighton, on page 6, I just kind of want to get this crystal clear. Page 6, line 12 is where it starts describing the application qualifications to the program. So then, starting with line 12, section B, says on receipt of more acceptable applications during the application period for admission under the subsection for available positions in the program due to insufficient funding, then they will be filled by positions by a lottery of applicants within each category as follows. On line 18, it says here, these are the important words here, for not more than 40%. So up to 40% of available positions, and then it stops in the program, will be children described by section 29.355A who are members of a household with a total annual income that it is below 185% of the federal poverty guideline. So the first 40% is for people who are living below 185%. Then on line 23, number 2, it states no more than 30% of the available positions in the program described will be for members of a household with a total income that is above 185 but below 500%. So I guess a little less poor. That's the next 30%, but no more than 30%. On the next page, for not more than 20% of the available positions will be for children with a disability described who are not accepted into the program under subsection 1 or 2. So now, even though you may have been poor and you didn't get in, but if you're disabled, you've got no more than 20% of the slots. And then on line 5, number 4, for any remaining available positions in the program, all eligible applicants who are not accepted in this program. So I'm trying to read this correctly. It appears to me that we limit how many people go into the categories of disabled, of the very poor, of the moderately poor, but then we open it wide open to anybody else afterwards. I guess that's where you come up with the universal portion, that this is universal if the other 90% that we've capped, but you've reserved 10% for anybody to apply. Did I read that correctly?
Well, yes, and the universal reference also, Senator Menendez, applies to the very beginning of the application process, because we don't know how many applications will come in.
Correct.
For an ESA.
Correct.
And so if the amount of funding that we have appropriated is not exhausted by the applications that come in, well, then everyone can be served that applies. That's why the bill is fully universal. Then you go to the framework. 90% of the framework assists students that are either low income or special needs or disabled. And again, even when you go from the 40 to the 30 to the 20 to the 10, a disabled student or a student with special needs can also be that free or reduced lunch student. So a student with a disability is not just in the 20% category. The student with a disability can be in every category, all through the framework itself.
They can, but they can't double dip, because I guess on line 3 of page 7 it says who are not accepted into this program under subdivision 1 or 2 of the subsection. And then the part that also, I guess, creates a little bit of concern, I'm completely opposed to the program, but on line 8 it says B-1. The comptroller shall adopt rules necessary to administer subsection B. So what rules do you envision the comptroller adopting? Because I thought you were pretty clear. And so my concern is, if we read whatever people are going to be voting on in terms of if they support this, they're doing it based on the framework that you've laid out. But then, right after the framework in section B-1, it says the comptroller shall adopt rules necessary to administer subsection B. Yeah? You're comfortable?
That's correct, yes. I'm comfortable with that framework, and at the end of the day, Senator Menendez, we've got to get a better understanding of who will be applying for this type of opportunity for more of a customized educational setting. Would it be predominantly students with autism, or would it be predominantly students that qualify for free or reduced lunch, but not as many students that are disabled or have special needs as we thought? Maybe they're very comfortable with the assistance they're getting in their public schools. Again, this bill's not a mandate. It's just an opportunity. And so with that opportunity, we'll gather, you and I together on the committee, we'll gather more and more information in knowing who is really seeking out these options and these opportunities that we're creating, even though we're a little late in doing so.
I asked the question in committee, but the only reason I'm going to repeat it is the committee didn't have the lime string while it was going on. So this is very important to me. Based on the fact that these are taxpayer dollars, this $500 million that you're asking us to set aside for these education savings accounts. And in committee, I said, what if two families were lucky enough, neighbors, to have children who qualified for an ESA? They came in under they got the lottery, the golden ticket. They applied to the same private school, but one was accepted, the other was not, and maybe the family that wasn't felt that they had been discriminated against for some reason. It could be any reason. They could be rejected. My understanding in your response in committee was that there's no desire to put any strings, attach any strings to private schools, and they can reject anybody for any reason. My concern is that families that might feel discriminated, they have no remedy under this bill. Is that correct?
Well, yes, we had that exact exchange, and my answer was that this bill doesn't change any remedies, create any remedies. It doesn't alter, any legal rights for any student, nor does it create any new rights. So it's very consistent. It's not within the scope of the bill to provide new remedies for an individual that feels like their rights have been violated. So one of the conversations we were having in committee and questions you were asking, I mentioned that there are obviously federal laws in place for private schools that accept any money tied to federal grants or federal funding whatsoever, that obviously they can't discriminate based on gender or race or special needs, disabilities.
And those are all good things. And I would love, at one point I'd asked you in committee if we could entertain an amendment to include protections in this bill for families who have these ESAs. And I think if I remember correctly, you said that I should file a bill if that was what I wanted to do.
Yes, when we were talking on the Senate floor, when we last considered this legislation, I mentioned that through the interim charge and committee process in leading up to the next regular session, that we could certainly work together on that, but that was not within the scope and intent of this bill. There are legal remedies in place today, whether this bill passes or not, and there will be tomorrow, whether this bill passes or not.
So in the bill, we're not creating any new legal remedies for any of the applicants, but it does, there's a clause at the end of section 2 on page 27, and I'd love it if you could help me understand, what is this right to intervene? That seems to create a legal remedy for the private schools.
Well, if there's agreement, it's standard language that many other states have modeled, that if there is a grievance or a legal remedy that needs to be pursued by the private school, that they can, and it just acknowledges that in the framework. So,
but doesn't it also have a provision that creates a question of constitutionality, because the appeal, if there's an appeal of that section, it goes straight to the Supreme Court. And so I'm just curious, we're not creating legal remedies for individuals, but we do have some for the private education sector or vendors who are receiving this. That's my concern, because it appears that this system, this new ESA, would allow the law to do in case they're being sued, to bring in other entities, not lawyers, to help support the defense. So I'm just curious. It feels as if we're actively planning for and on the side of private groups taking public dollars instead of the side of parents attempting to stand up for their constitutional rights. And so that's what I'm concerned about, that right to intervene clause.
Well, and this legislation is about empowering Texas families and Texas students, right? And that provision that you mentioned and just acknowledged is very consistent, that if there was some sort of grievance, some sort of litigation that was brought forward on behalf of one of these students, that there would be a fast track provision so that there would be answers quickly as possible through a very long process. Normally, that anyone brings litigation forward, they're waiting years to get an answer. And students deserve a fast answer, as fast as it possibly can be within our judicial system. But
the right to intervene, isn't it one that actually helps the private schools and the vendors, not necessarily the students? That's where I'm confused.
Well, the student would be a student of the private school. It would be on behalf of both to get answers to legal questions that are lingering but yet unresolved.
Okay. Thank you for taking my question.
Thank you, Senator Menendez.